Divine Love family. So we are going over the reclamation process. This is the first step. So what is the reclamation process? The reclamation process is reclaiming back rights that you never knew you had, reclaiming your status, correcting your status, and reclaiming any lands or properties or heir lands or heir estate that you may have knowingly or unknowingly, because there's a whole trust that has been attached to your existence since you were born. So many have been talking about the executor process or secure party creditor and things like that. But I'm coming to you from an indigenous standpoint. The root of all things starts from the beginning. So, Aborigines and Aboriginals, indigenous inhabitants are first in line. First in line is first in time. So, they're talking about our accounts that have been utilized by the state or by whatever entity holding it, unbeknownst to us, that should have been turned over to us at the age of majority, which is 18 years of age. Since we did not know this, our trust estates have been in the hands of the so called governments. These governments have not performed their proper fiduciary duties in acknowledging, informing, and executing our estates to us as they are supposed to. So, this process, first of all, it preserves your rights. All rights should be preserved at all times. Some people say reserved, I say preserved at all times. This ensures that you are taking a lawful stance and making sure that anyone that you are doing business with or having a contract with knows that they cannot create any adhesion contracts after they leave your site. Many times, if you do not express that your rights are preserved or reserved, then that governmental entity or that entity that you are doing business with or made a contract with will and has on many occasions, because this is what they do, especially in governmental entities. They use your contract or they use your signature for other purposes for which you had not acknowledged or intended. So it's very important to make sure that your status is correct and that you have preserved all of your rights. So we're going to go through the first step of the reclamation process, which includes status correction, preserving your rights, and taking ownership of your estate and any lands or heir lands that are owed to you. This includes royalties, entitlements, and even rulership and governance. Because if you own land, a substantial amount of land, you are an heir to an estate in which you have to be the ruler, the executor over that estate. So, this is the document that you can download for free. The first step on knowledgebase.live. The first step in the reclamation process. Read carefully. Where you see underlined words, change it to your own words. This is not a cookie cutter. You must put your own words and title of nobility appellation, pardon me, like we say appellation, that's the correct term for name. Okay? Put that into the document. Do not leave the underlined instructions in the document. Proofread everything before you send this to anyone. There are other guidelines and documents to your path to freedom. This is your first step. If you have any questions, you can email Empress Royal Courts at Proton Mail. That is my only email. I do not have any other email dealing with Empress Courts, Empress Royal Courts. First step in the reclamation process, free download at knowledgebase.live. So this is the affidavit of revocation. You get the registered number and you put it here. That is as good as gold. That is money. That's another lecture for another day. This is actual, lawful, and constructive notice. You put the date here. You put your name in lower caps here. That means that is the living soul coming forward in your proper person. And you're saying to all whom sees this notice, this affidavit, in public record, if you send it by mail or if you put it in a court case, you're saying, I hereby affirm the title of nobility, whatever your indigenous appellation is that you have upgraded to, is the executor for, you put your birth certificate name in that line. That is attached to the Sister K Trust. You are telling the fiduciaries who have been holding on and benefiting from this trust that they shall now refer to you as your tribal name and your title of nobility. From this day forward, refer to me as, you put your appellation there and your tribe. Underneath, the international protections of the Aborigine Moors of America Empire. Imperial Great Seal, Proclamation, Declaration, and Charter, annexed by an Act of Congress. TXU 2-049-663 is our solidifying document filed at the Library of Congress. And that is the number where you can find that Library of Congress document. Okay, next you are saying, I put, oh wait, next you say I, and then you put your name in lowercase there, in my proper person as title, the appellation that you've chosen you put there. Hereby cancel, revoke, remove, and rescind all contracts that have put you in a contract. And you put your birth certificate name in upper caps, capital letters, where this line is. And it's saying that you have canceled, revoked, removed, and rescinded all contracts that you have entered into knowingly or unknowingly, that the state of whatever state you're in and the U.S. corporation, whatever city you're in, and its corporate entities, local, county, municipalities, and or federal corporate governmental entities Your fiduciary charters are null and void pursuant to this beneficiary demand. And Pope Francis, motu proprio of 2014, H.R. 1624, United Nations General Assembly Decolonization 1514, which means that decolonization is in full effect. Additionally, pursuant to the U.S. State Department's issuance of the Potomac Plan and Potomac Declaration, we, the Aborigine claimants, shall not be forced into assimilation of the colonial Christian powers, tyranny, or forced contracts under duress, threat, or coercion regarding any travel on land, court cases, charges from state or federal entities, venues, attorney agreements, powers of attorney, probation, pretrial agreements, or restitution with the U.S. courts, U.S. courts, U.S. corporation. Contracts shall now be canceled, revoked, removed, and rescinded, rendered null and void at law in the matters of, put your appellation there in lower caps. There shall be no adhesion contracts acquiesced or accepted. There shall be no waiver of rights. There shall be no presumable contracts or agreements that exist between the living soul. Put your appellation, your new indigenous name there. You are the affiant in this matter. You are the one who has created this affidavit. And any admiralty, maritime, court, state, federal, or corporate entities. The heir, put your name there, put your, pardon, your appellation there. Claimant to the land shall never be presumed a U.S. citizen or corporate ward of the state. Sovereign rights not ever waived. When you are standing in your proper status as an heir to the land, a sentient being, aboriginal, aborigine Moor, imperial Moor, whatever title that you are proclaiming, as long as it is of the de jure status, you have sovereign rights that are on the law books that shall not ever be waived. So these are the rights that you have to start learning and operating in order for you to benefit from these rights. So that means when you are coming from a standpoint of an Aborigine inhabitant, an indigenous inhabitant of the land, you need to stay there. It's my advice for you to stay there. Don't flip flop into corporate status, back into de jure, back and forth, back and forth, back and forth. Because that's when you get into a lot of misunderstanding and get caught up in a lot of things that are unnecessary. We are in a day and time that I know we should be dealing with our status. Because when it's all said and done, everything is going to boil down to the land. So make sure you're on the right side of the law. Aboriginal heir to the land. You sign here. Take out all of this. Once you fill out the form and fill in all the blank lines, take all of these notes that I have left out from the document. Do not leave these notes in this document. Go back and Put your name, start your name there, and put it in there. Then erase every one of these notes out. Do not leave the notes in there. Okay? All right. This is just for your edification to know where to input something. And I always, when I'm doing an affidavit, and when you're dealing with the courts or you want to use a notary, because the notary is already in the jurisdiction of the court. If you do not want to be in the jurisdiction of the court or the state, this disclaimer here comes in handy. And it says the use of a notary is not an entrance or acquiescence into a foreign jurisdiction. It's only for verification of identity. All right. And also, the other option, you can use two witnesses to sign for you on an affidavit. Here are some further instructions on the last page. Make sure you use a cover page. Follow these instructions. Cover page should read Declaration of Irrevocable Trust. Placing the reclamation and any other documents with the real estate collateral as property of your irrevocable trust. You do not ever reveal the contents of your trust. You do not have to. That is not anyone's business but your heirs and the beneficiaries you are leaving that trust to. Number one, construct a one-page declaration of trust. It can be a living trust, irrevocable trust, or just a executable trust. There's many different types of trust, which I talk about in my trust course. Number two, add the attachments after you read them, making sure all is correct. Number three, file the irrevocable trust declaration page with the affidavit, or actually the reclamation. Any paperwork should have a cover page similar to this. It's very important for everyone who files a trust to take your time adding all your property into it. Any known properties or any properties that you find in the records that are associated with your lineage. Aborigine Moors, indigenous reclamation. You can go to empressinamerica.com to read more about it and get more instructions and download the disclaimer and the other documents that's required. You need your birth certificate, a copy of it, the proof of existence, and your identification. You can put titles and deeds into the record. Include all court cases, anything that you want to take ownership of. Add those as exhibits attached to the Declaration of Trust. If you have any real estate, add the legal descriptions when recording in county records or court records. This document will follow all of your legal paperwork. Use it as your common address as well. Make sure that you get the Declaration of Trust certified before leaving the Register of Deeds. Get 3 copies. Keep one on you at all times. File one within the court case if you have one ongoing, and send one to the fiduciaries. Who are the fiduciaries? They have fiduciaries at many levels. There's a bankruptcy fiduciary, there's a court and a fiduciary in the superior court, and there's the Secretary of State, there's treasurers, there's a lot of fiduciaries and trustees who need to hear from you. So then you register, send it by registered mail to all the trustees, CC them copies to your state's insurance commissioner. That's who holds the bonds, the court bonds. Department of Justice, responsible for protecting the beneficiaries, the court administrators, state district attorney, federal district attorneys, they all have to follow your orders as the beneficiary. The registered mail receipt number is like gold. Do not ever lose it. Make notation of it on all of your communications to the state, the courts, any entities you deal with. They all should know your status. You are not a citizen of the United States corporation, company, or any corporate ward of the state. You have to know that you are a citizen, if you want to call it that, attached to the lands of America. You have to know the difference between a corporate status and a de jure status. The indigenous side of things is known as the de jure side of governance. You are attached to the land with beneficial ownership status. Benefits should be coming to you. You upon demand, the welfare, social security, government funds, etc. You do not jump through hoops for what is entitled to you. You do not apply, you demand. Okay? You have to know that you are a beneficiary, a living sentient being, and you are attached to the land, and you have to learn how to execute your estate. Or else somebody else and some department or governance or municipality will be administering your estate for you, unbeknownst to you, and collecting wages and funds and the benefits that should be coming to you. Ashe. So that's how it's been going. That's how it goes. That's why we're doing what we are doing. We're learning how to be the executors over our own estates, especially the Aborigine of America. The indigenous populations of the Americas were born with a trust account. This was set up by the empire around the year of 1913. Before the year of 1913, when the empire went into interregnum. These things were already set up for us in America. We are rich. We were born rich. And this is why everybody in all other countries want to be in America living off of our wealth that we never knew we had. So this is the conclusion of this video presentation of the affidavit of revocation. Visit knowledgebase.live for more events, live events, and knowledge you can use like this Till the next time, peace and divine love. This is Empress Nancy L. Bay, and I'm over and out.